Hello and welcome to the Week 1 online lecture for LWS011 Journalism Law. I'm Peter Black. The topic this week is an introduction to the Australian legal system. We're going to have a look at a little legal history because to be able to understand how our system of law operates today, we need to know where it has come from. We'll then look at the way power is divided in the Australian legal system. It's divided in two main ways. It's divided between the federal government and the state governments. That's referred to as a federal system, so we'll talk about that, before then looking at the other way that power is divided, which is between the three branches of government, which, as we will learn, is the judiciary, that is the courts, the parliament or the legislature, as well as the executive. And then finally, we'll look at the sources of law. Law doesn't just come from one place. In many ways, it flows from those three branches of government. So we'll talk about that. The idea behind all of this is so that at the end of the first week of this unit, you have some basic familiarity with how the Australian legal system operates. You need to understand just basically how the system works before we can go on and look at some discrete areas of law that are more relevant, specifically for journalism students. So let's begin with a little legal history. As I've said, some familiarity with our legal history is necessary for you to understand how and why our modern political and legal institutions developed into what we know today. And we have to go back to 1788, which is when Australia was colonised by Great Britain. Now, this is significant from a legal point of view, because it's not as though when Australia was colonised by Great Britain in 1788 that we started from nothing. It basically meant instead that we received our modern legal system from Great Britain. And this took on a number of different dimensions. We inherited the legal system from Great Britain, which means that we inherited from there the way that we have a parliament, the way that they have a court system, and the like. It also meant that we didn't start with no laws, we started with the law of England, and that then became the law of Australia at the time of 1788. But in addition to just what the law was, it was also a matter of the various legal procedures, the values and traditions, and also the very notion of a legal profession, with both barristers and solicitors, were all inherited from Great Britain. So it's not as though we started our own unique or novel legal system. We adopted and inherited the system that we got from Great Britain. So we need to understand a little bit about that system to be able to appreciate how the law operates today. Now, relevantly, there were two key features of the English legal system that we inherited at the time of colonisation in 1788. The first is the three branches of government, and the second is this idea of the rule of law. Now, we're going to talk about the three branches of government in a little bit more detail later on in this podcast, but it is just worth noting for current purposes that the idea behind there being three branches of government is that power is best divided or separated between different institutions within government, rather than being concentrated in one person or in one particular legal entity. The idea being that power corrupts and absolute power corrupts absolutely, and so to mitigate against that, the idea was you separate government power between three different branches of government. And the three branches of government are the judiciary, which is the court system, the legislature, which is our parliament, and then the executive government. And the idea here, just very basically, is that the legislature makes the law, the judiciary enforces and interprets the law, and the executive administers the law. But as I said, we will talk more about the three branches of government a little bit later on in this podcast. The other really fundamental and important idea that we got from the English legal system is what's known as the rule of law. And this is the idea that government has to be subject to law. Nobody is above the law, be it the monarch, be it the elected representatives, be it powerful business or lobby groups. The idea here is that everyone is answerable to the law. There is equality before the law. And that notion very much underpins the way that both the English legal system operated as well as the Australian legal system operates today. So the fact that we inherited from Great Britain these two very important features of their system of laws is very significant to how our legal system evolved and developed over the following hundreds of years. Now, after we received all of this English law at 1788, that is, we received the fact that we have this separation of powers, we received exactly what was on the books as the law in Great Britain at the time of 1788. But from that point in 1788, we began to diverge from what was going on in England. And this was because Great Britain granted limited self-government to each colony. So this meant that the various colonies throughout the continent of Australia had their own parliaments and courts, and they were generally free to repeal, amend, or add to that ordinary English law that had been received at the time of 1788. And so over the following decades, we began to see a notion of Australian law develop that was separate to exactly what the law was in Great Britain. And so what we saw over time was an independent body of Australian law being built up by the legislatures and the courts of the colonies. The time then came in the late 19th century for Australia to gain even more independence from Great Britain. Throughout the 19th century, Australia was very much just a colony of Great Britain, an outpost of Great Britain. It was not its own nation state. This changed in 1901 when Australia became a federation. So let's look at that particular process. Now, we talk about federation at the time of 1901. What do we mean by that? Well, fundamentally, we're talking about Australia adopting a federal system. Now, a federal system is a political system in which government power is shared between a central or federal government and regional governments. And so the way that this operated in Australia was that at the time of federation in 1901, they created a federal or national government and then made the various colonies the various state governments. Now, this all took place, or the movement towards this all took place in the preceding 2 decades or so. The federation movement gained momentum in the 1880s. There were several national conventions, and eventually the colonies passed referenda, whereby the people of those colonies agreed for Australia to become a federation. And ultimately, the British Parliament passed the Commonwealth of Australia Constitution Act 1900 on the 5th of July 1900. Now that's quite significant because it means that the Australian Constitution, which is the document that explains and sets out how our system of government and how our system of laws is going to operate, is actually contained in an act of the British Parliament. Indeed, when you look at that Act of the British Parliament, you find that the Australian Constitution is actually set out in Section 9 of that British Act. There are a few other unusual things about this British Act as well. So, for example, if you look at Section 6 of the British Act that contains the Constitution of Australia, you will find that they contain this definition of the states, which says the states shall mean such of the colonies of New South Wales, New Zealand, Queensland, Tasmania, Victoria, Western Australia, and South Australia. Of course, this was because at the time there was some possibility that New Zealand was also going to become one of the states of Australia. Now, ultimately, that didn't happen by the time of federation on the 1st of January 1901, but at the time, the British Parliament passed the Commonwealth of Australia Constitution Act on the 5th of July 1900, there was still that possibility. Another strange thing about this British Act is when you look at the preamble to this Act, it begins as follows. Whereas the people of New South Wales, Victoria, South Australia, Queensland and Tasmania, humbly relying on the blessing of the Almighty God, and on it goes, What's unusual about that, if you were paying attention, is the fact that Western Australia was not mentioned. And that's because, again, at the time, the 5th of July 1900, it was not clear that Western Australia was actually going to become part of the Federation of Australia. So there's a few historical peculiarities in the fact that the Constitution of Australia is actually contained in this Act of the British Parliament. Nonetheless, despite that, on the 1st of January 1901, Australia's first Governor-General performed an official ceremony and the modern nation of Australia came into being. Who was Australia's first Governor-General? It was a man by the name of Lord Hopetoun. As to who is Australia's current Governor-General, I'm hoping that your own general knowledge will know this, and the multiple choice question will test this. So, what are the consequences of the fact that Australia adopted a federal system of government all the way back in 1901? What this means is that we have two levels of government. We have the Commonwealth or federal government, and then we have the various different state governments. And within each of those levels, there are those three branches of government. So we have Commonwealth or federal courts, Commonwealth or federal executive government, and Commonwealth or federal legislature. We also, though, have state courts, the various state executive governments, and the various different state legislatures. So, two levels of government divided between these three branches of government. And all of this is regulated by the Commonwealth Constitution. Now, the Commonwealth Constitution carries out 5 main tasks. First, it recognises the existence of the 6 Australian colonies as they were in 1900 and continues in force their constitutions and laws except as changed by the Commonwealth Constitution. So what this means is that prior to Federation in 1901, we had the various different 6 Australian colonies that existed. They had various limited forms of self-government. One thing that the Commonwealth Constitution did was to say, look, the 6 colonies are now the 6 states. And the constitutions of those 6 colonies now become the constitutions of those 6 states, except as changed by the Commonwealth Constitution. So that was the first main task that the Commonwealth Constitution had to do. The second thing that it did was that it created a new set of federal or Commonwealth authorities of the central government, and it outlined their functions and powers. Now that's significant because, again, prior to Federation at 1901, there was no federal or Commonwealth government. There were the 6 colonial governments, and they responded to Great Britain. There was no one overarching national government. So one thing that the Commonwealth Constitution had to do was to create a Commonwealth or federal government and give them their various different functions and powers. So that's the second thing that the Commonwealth Constitution did. The third thing that it did was to regulate the relations between the Commonwealth authorities and those of the states. And the main way it did this was by basically dividing power between the Commonwealth and the states. In section 51 of the Commonwealth Constitution, you find a long list of topics that the Commonwealth government is able to make laws about. And basically the rest, if it's not in that list, have been left to the states. And there are a few other sort of mechanisms that the Commonwealth Constitution set out in terms of regulating the relationships between the Commonwealth government and the various different state governments. It also established an Australian common market by providing for free trade between the states and a common external customs tariff. It's interesting, one of the main drivers behind the push to federation and behind the push to independence that took place in the 1880s and 1890s was motivated by free trade between the colonies. And so you do see this as very evident in the text of the Commonwealth Constitution. The fifth thing that it did was that it established very limited Bills of Rights provisions. And that's also worth noting. The Australian Constitution is relatively unique in the sense that it doesn't contain many rights provisions. And that's because when we were moving towards federation in the 1880s and 1890s, it wasn't as though we were really rebelling against Great Britain or any sense of being oppressed by Great Britain. It was more that it was seen as the next logical step, and because there was this real drive and motivation towards free trade between the states. So rights were not forefront of mind when we were moving in that direction. That said, the Commonwealth Constitution does contain a few very limited express rights. There is, in section 92 of the Constitution, what's referred to as the freedom of interstate trade and commerce. That's significant, as I said again, because it goes about establishing this Australian common market and by providing for free trade between the states. So section 92, freedom of interstate trade and commerce. There is also a section 117, which provides for a prohibition on discrimination on the basis of residency. And it's only discrimination on the basis of residency. What that basically means is that one state cannot discriminate against the residents of another state. So that's section 117. There was then a strange right, perhaps, in section 51(31) of the Commonwealth Constitution, that is section 51, subsection 31, which provides for the power for the Commonwealth government to acquire property on just terms. So this is a right that basically says the Commonwealth government is not able to acquire property on something other than just terms. And indeed, this is the provision that was at the very heart of that movie, The Castle. The fourth right can be found in section 80, and it provides for a trial by jury on indictment of any offence against the law of the Commonwealth. So it provides for a jury trial, but only when we're talking about Commonwealth laws and only when you are dealing with a matter on indictment. So it's quite easy for the Commonwealth Parliament to get around, but nonetheless, there is that right to a jury trial there in section 80. The fifth and final express right that the Commonwealth Constitution contains is a more conventional right, and that's found in section 116 of the Commonwealth Constitution that deals with freedom of religion. Interestingly, the right for freedom of religion provided for in section 116 uses very similar language to the First Amendment to the Constitution of the United States, which provides both for freedom of religion and freedom of speech and the press. However, when the Founding Fathers were drafting the Commonwealth Constitution, they only included the freedom of religion and made the decision not to include an express protection for free speech or a free press. But as we will see in the podcast next week, the High Court has been able to get around this a little bit by finding an implied freedom of political communication in the Commonwealth Constitution. Anyway, that's just a very brief introduction to the Commonwealth Constitution. Let's now move on and have a look at the three branches of government, something that I referred to a little bit earlier in this podcast. And as I said, the three branches of government are the Judiciary, the Legislature, and the Executive. And so what we're going to do now is to spend a little bit of time looking at each of these three branches of government, both in terms of how they operate, but also in terms of how each of these three branches actually act as a source of law. That is, each of these branches do in some way create and make law. Let's begin by looking at the Judiciary. Now, the Judiciary is basically the courts, our court system. Now, what's important to appreciate about our court system is that each court has a different jurisdiction. So what is meant then by jurisdiction? The definition that I've used comes from the Butterworth's Australian Legal Dictionary, and it says that the scope of a court's power to examine and determine facts, interpret and apply the law, make orders and declare judgment. Jurisdiction may be limited by geographic area, the types of parties who appear, the type of relief that can be sought, and the point to be decided. So what this basically means, though, is that it's not as though all courts are equal. Not every court can hear every matter. Some courts have to go, or some matters rather, have to go to different courts. And this can be divided and worked out in a couple of different ways. The three main common ways that we think about jurisdiction is that you often will have federal jurisdiction versus state or territory jurisdiction. What this means is that, but as we've said, we have power in this country divided between a federal government and our various different state governments. And so we have federal courts and we have our various different state courts. Federal courts hear matters of federal law. State courts generally hear matters of state law. So that's one way that we can sort of divide up these various different courts. There is also a distinction between civil and criminal matters. So not all courts can hear all civil matters, not all courts can hear all criminal matters. So in a civil matter, we're talking about someone suing another person. In a criminal matter, we are talking about someone being prosecuted for breaking the law. And there's a slight difference between, or not just a slight, it's actually quite a significant difference between being sued for someone by someone and actually being prosecuted for breaking the law as a criminal matter. But we'll talk about that as well. And then the third sort of main way that we can think about the jurisdiction of these different courts is between what's known as a court's original jurisdiction versus its appellate jurisdiction. So if we talk about the court's original jurisdiction, we're talking about a matter being at first instance or the matter going to trial. But if we're talking about a court's appellate jurisdiction, we're talking about the situation whereby one party can appeal a decision of a court to another court. So just because a matter goes to court, that does not mean that is the end of it. If you are unhappy with the decision that has been reached at first instance, that is the first time it's gone before a court, you will often have the ability to appeal that to a different court, to usually a higher court, and they will be able to review that original decision. And so some courts have original jurisdiction and some courts have appellate jurisdiction. So let's think then about each of these, particularly the distinction between civil and criminal as opposed and also then original and appellate. So in terms of civil jurisdiction, as I've said, we have federal courts and state courts. Now, federal or Commonwealth laws have set up the federal courts and have given them jurisdiction over areas of federal law. This will include things like trade practices and consumer protection law, taxation and bankruptcy and insolvency, immigration and family law. Sort of all matters that are matters of federal jurisdiction which end up before federal courts. Now, state laws set up the various different state courts and they give them jurisdiction over other matters, such as contract law. So enforcing contracts is a matter of state law that will end up before state courts. Remedies in tort law. So mainly here we're talking about things like negligence or defamation. These are state matters, and so they're heard by state courts. And also land and property law matters tend to be matters of state jurisdiction that are heard by state courts. And with all of these different areas of law, what we're normally talking about here is a situation whereby one person, be it an individual or a company or whatever, has been wronged in some way, and so they make the decision to sue someone else, another individual or a company, for not complying with their legal obligations. So that's a court's civil jurisdiction. We also need to think about the court's criminal jurisdiction. Now, most criminal law is a matter of state law, and even federal criminal law is heard by state courts. So state courts have jurisdiction over all breaches of Commonwealth criminal law, as well as over all breaches of state criminal law. And so we only need to consider one particular court hierarchy when we're talking about criminal law. And we'll focus on Queensland because obviously enough we are based here in Queensland. Now, there are two ways for a court to hear criminal offences. The first way is for a matter to be heard on indictment, and then the other matter is for it to be heard summarily. If it's heard on indictment, that is before a judge and a jury, either in the Supreme or the District Courts, usually following a committal or preliminary hearing before a magistrate to determine if enough evidence exists to put the defendant on trial. So that's worth noting, that serious offences are heard on indictment following a committal or preliminary hearing in the magistrate's court. Matters can also, however, be heard summarily, that is before a magistrate sitting alone. And there are essentially two types of criminal matters. There are indictable offences, which are referred to as crimes and misdemeanours, which are serious offences. And then there are summary offences, which are simple and regulatory offences, which are less serious and are always tried summarily. The next way to think about jurisdiction is to make, again, that distinction between a court's original jurisdiction and its appellate jurisdiction. So what do we mean by a court's appellate jurisdiction? Well, it goes down to what do we mean by an appeal. Again, the Butterworth's Concise Australian Legal Dictionary tells us that an appeal is an application to a higher court to reconsider the decision of a lower court on the ground that there has been an error in the decision of the lower court. Now, an appeal can exist either as of right or with leave. What this means is that some instances you will automatically have the right to appeal, whereas in others, sometimes you will have to get the permission or the consent of that court to appeal to it. Now, when appeals are heard, they may be dismissed, that is thrown out, and the original decision stands. They may be upheld, which means that the appeal is allowed and the original decision is overturned. They may be remitted back to a lower court to reconsider, or they could be allowed in part, which is they might agree with some of the appeal, but not with all of it. So again, some courts have an appellate jurisdiction. So let's look briefly at the outline of appeals in civil matters. So this is the basic, what we refer to as the court hierarchy. Now we have the highest and most important court right at the top of this particular diagram, and the lowest court down the bottom, the magistrates' court in state jurisdiction, or what is now referred to in the federal jurisdiction as the Federal Circuit Court. It's no longer referred to as the Federal Magistrates Court, but apart from that, the diagram remains accurate. So if you start off at one of those lower courts, in some instances you have the right to appeal, and some instances you need to get leave to appeal, to go to one of those higher courts to basically re-argue the point and to contend that a mistake was made when the matter was first heard before the court. So you should become just basically familiar with that particular court hierarchy and the fact that some of these courts have both an original and appellate jurisdiction. The appeals in criminal matters is a little bit simpler because it is only dealt with in the state courts. And so again, similar process, but just within the state court system. We don't have to worry about the federal courts getting into the mix. So that's the basic court hierarchy. Now, before we move on to consider the next branch of government, which is the legislature, I just want to talk for a moment about how the courts and the judiciary go about making law. So it's important to appreciate that the courts don't just apply the law, they also make the law. And the body of law that is or has been made by the courts over the centuries is referred to as the common law. So the common law refers to the body of law that has developed through the recording of the decisions in cases coming before the courts. And the way that this works is because of what's described as the doctrine of precedent. What this means is that courts are generally bound by decisions of higher courts in the same court hierarchy. So the idea here is that we want the law to be fair and we want the law to be consistent. And so if a very similar factual scenario goes before one particular court, and that same or very similar scenario has already been decided by a court higher in the hierarchy, then that lower court will have to follow the decision of the higher court. So to think about that in the context of those diagrams, we look at appeals in criminal matters. What this basically means is that the High Court of Australia right at the top, if they have decided a particular matter and a case that has very similar facts to that appears before one of those lower courts in the hierarchy, so either even the Supreme Court or the Magistrates Court, they will have to follow the ruling of the higher court. This way we get consistency and we get fairness. Similarly, if we're looking at appeals in civil matters, the courts at the top of the diagram get to set the precedent, and then the courts lower down on that diagram have to follow the precedent. That's what's referred to as the doctrine of precedent, and it means that decisions of courts higher, or that the courts are generally bound by decisions of courts higher in the same court hierarchy. And the body of case law that is developed over the years through this is referred to as the common law. Now, in this explanation, I've spoken about matters or cases a few different times, so it's probably worth just taking a moment before we move on to look at the next branch of government to consider what I mean by a case. So, what is a case? Basically, when a court sits to consider and decide a matter that is in dispute between two or more parties, it is hearing a case. The individual matter before the court, its facts and parties, and the decision made by the court is all known as a case. Now, the decision or judgment delivered at the conclusion of the proceedings by the court who is hearing the matter decides the outcome of that case, and may also provide a judicial statement on a legal rule that may become a precedent for other cases that come before the legal system at a later time. So, that then is our very brief introduction to that first branch of government, the judiciary, and how they go about making law. Let's now consider the next branch of government, which is the legislature. The legislature is basically the parliament, and as we've already seen, there is a federal parliament as well as a parliament for each state and territory. Now, most parliaments consist of an upper house and a lower house. So, for example, the federal or Commonwealth Parliament has the Senate, which is described as its upper house, as well as the House of Representatives, which is described as its lower house. Queensland, however, is unique in Australia, having abolished its upper house, which was named the Legislative Council back in 1922. Queensland is the only Australian state that doesn't have two houses of parliament. We are instead what's referred to as a unicameral legislature, as opposed to a bicameral legislature. Now, what does the legislature do? Legislature makes law, and this is referred to or described as legislation. In Australia, this includes statutes that are enacted by both the Commonwealth and the state parliaments. Now, legislation provides a more flexible method of lawmaking than the common law. This is because in most instances, the Parliament is free to vary existing statutes or to introduce new statutes as it wishes. That is to say that the Parliament can wake up one day and decide to make a law on a particular topic or change a law on a particular topic, whereas the courts have to wait for a case, that is, for a dispute or a matter, to come before it can move the law in a particular direction. The judges just can't wake up one day and say, this is what the law is going to be about X, or this is what the law is going to be about Y. They have to wait until a case comes before it. Whereas the legislature, much more flexible, they are able to introduce a law or vary a law pretty much as it wishes, as long as it complies, that is, with the procedure and the limitations contained in the Constitution. Now, legislation, as we've seen, is sometimes referred to as statute or statute law, but there's a range of other different terms as well. So including acts or acts of parliament, enactments or enacted law, which can be compared with enacted law or case law. And this term legislation is generally used as a generic term to include both statutes as well as delegated legislation. Now, delegated legislation refers to legislation such as rules, bylaws, regulations, ordinances, orders in council, whatever, which are lower level examples of legislation and may be made under an empowering statute. And in fact, when we're talking about delegated legislation, that is actually rules or laws that are made by the executive under or pursuant to legislation which has been passed by the Parliament. So you might have some legislation that empowers the executive to make certain rules or regulations or bylaws on a certain topic. Now, what then is the interplay between legislation and the common law? The general rule is that the law made by Parliament is supreme over judge-made law. So that is that legislation trumps the common law. The only way in which a court can override a law made by Parliament is for the court to find either that, first of all, proper procedures have not been complied with in enacting the law, or that the Parliament does not have the power under the relevant constitution to make a law of that nature. That said, if both of these requirements have been satisfied, The courts cannot say that a law is invalid just because in their view it is a bad law, or the courts would have preferred some sort of different wording. Now, most of what we're going to be looking at in this semester is really legislation, but we will occasionally be touching on the common law as well. Now let's consider the third branch of government, which is the executive. The executive branch of government is responsible for administering the law that has been made by the legislature and interpreted and enforced by the judiciary. Now, executive power is described as being vested in the Crown, but hopefully you know that it's not as though the Queen herself regularly exercises this power. Rather, this power has been granted to be exercised by others. Now, in Queensland, executive power is exercisable by the Governor-in-Council. So the Governor is the Crown's representative, the Executive Council is the Premier and all the members of the Ministry, and the Governor-in-Council is a title used when the Governor is acting by and with the advice of the Executive Council, that is, with the advice of the Premier and the Cabinet. And that's normally how executive power is exercised. It's notionally done by the Governor, but the Governor acts on the advice of the Premier and Cabinet. Similarly, at a Commonwealth level, this power is exercisable by the Governor-General in Council. The Governor-General is, again, the Crown's representative, who is advised by the Executive Council, which consists of the Prime Minister and the Senior Ministry, or the Cabinet. So once again, although the Governor-General appears to be exercising executive power, the reality is that the Governor-General acts upon the advice of the Prime Minister and Cabinet. So, to recap, there are two main sources of law that we're going to be looking at this semester. The first is the common law, which is judge-made law, and then the other is legislation, which is law made by Parliament. Now, one question that commonly gets asked here is, what about international law? So international law is only enforceable in Australia if the Australian Parliament has chosen to enact it. So that is to say that an international convention or a treaty that may have been made at some international level is not going to be Australian law that can be enforced by Australian courts unless the Parliament has decided to pass a law that gives effect to that international law. So international law really only derives its authority when individual nations choose to follow it. So that is why some people really believe that the claim that international law is a little bit of a misnomer. We don't need to worry too much about that for current purposes, but just be aware that international law is not directly binding on Australia or Australians. It is only going to have legal effect in Australia if the federal parliament chooses to sign that international law and then they give effect to that law in legislation that has been passed by the Parliament. Now, a few just closing remarks that you might want to think about in relation to this introduction to the Australian legal system. First is, if you're curious as to how to access some legal materials, there are two good resources. There is what's described as OSLI, that contains a lot of case law and a lot of legislation, and then there is also ComLaw that contains or Commonwealth legislation. If you're not sure how to cite or refer to any of these legal materials, I'd suggest you have a look at QUT Cite Right. Also, while we've been focused on the three branches of government this week as the main sources of law, it is worth remembering that law happens in a lot of other different places. It's not just Parliament and the courts. There's government tribunals or bodies, coroners' courts, royal commissions and other commissions of inquiries, private places like sporting tribunals as a form of law, and there's a growing field in what's described as alternative dispute resolution, which is mediation and arbitration to resolve disputes rather than ending up before a court of law, which can be quite expensive. A lot of law also happens without you necessarily knowing about it. So if you're seeing a solicitor about wills, conveyancing, setting up companies, arranging contracts, getting help with litigation, this is all dealing with law. Dealing with government and its agencies, driver's license, council building permits, tax returns, all of this is regulated by the law. And of course then even dealing with non-government bodies often involve some sort of legal questions, including APRA and the MEAA. And finally, for your interest and help, if you haven't yet dropped into a court to have a look what goes on, I would encourage you to do that. You can look at the court listings to get a feel for the matters that are on either in the newspaper or online, and certainly read stories in the newspapers relating to legal matters. Often you will find a number of these in the business pages. And don't just focus always on criminal cases, there's a number of civil cases as well that are reported. This then brings us to an end of this first online podcast for LWS011. The next online podcast will deal with freedom of the press and free speech. Thank you.